Let me come straight to the point. Um, I thank you for this opportunity for saying a few words on India's anti-terror laws. I'll try to be as brief and as precise as possible. Um, well, um, there is something that distinguishes anti-terror laws from ordinary criminal law. And what we are concerned about in India today is that this difference between anti terror laws and ordinary laws is being collapsed. In my opinion, the main reason for collapsing these laws is to keep people under trials behind bars for indefinite periods of time, because these anti terror laws contain very stringent provisions for the grant of bail, which I will deal with at the present moment. So we are talking about nothing less than the very heart and soul of the rule of law, which says that we are all presumed innocent until proved guilty. There is no universally accepted definition of what is terrorism worldwide. What we have is sectoral resolutions of the United Nations which deal with, say, hijacking of aircrafts or terrorism of ships or terrorism against nuclear establishment, but no clear definition of what is meant by terrorism. As I understand it, the offense of terrorism consists of an act of intimidation which is intended to make governments do or not do things which are illegal by violent means, the impact of which is felt on ordinary citizens. But as I said, there is no definition that I've been able to lay my hands on. Let me talk about India's anti-terror laws. The hallmark of India's anti-terror laws is that they deny to an under trial the right to bail. And this means that if a trial goes on for 10 years, 14 years, 15 years, a person accused of terrorism who might ultimately be acquitted can be put away behind bars for that long. A few examples, which I will deal with presently, will suffice to make this point. But for the moment, I wish to point out that India doesn't have, for example, a law such as Mirandizing the accused. The police are not obliged to tell an accused that they don't have to make a statement to the police and that they have a right against self-incrimination. And this often leads to confessions being forced from those who are accused of terrorism. Now, what is it about these terrorist laws that makes it so easy for governments and prosecutors and the police to accuse people of terrorism in the first place? It is the overbroad definition of what is a terrorist act. And this is what Sunita pointed out too at the very commencement of these proceedings, that the Delhi High Court has said you are basically using an anti-terror law to deal with your dissenters. Why does it happen? It happens because the definition of a terrorist act is overbroad. Let me just tell you how it's defined under Indian law. It says whoever does anything with intent to threaten or which is likely to threaten, mark these words, please: the unity, integrity, security, sovereignty of India, with intent to strike terror or likely to strike terror in the people or any section of the people, commits a terrorist act with lethal weapons, which is likely to cause death or causes death. Now, if you see the two most prominent cases going on in India today, one is what has come to be known as the Delhi riots case, and the other is the Bhima Koregaon case. You will find that in both of them, there is no allegation against the accused that they attacked the sovereignty, the unity, the territorial integrity, or the security of India. At best, the allegations against them were of being part of a riot in which people lost their lives. Now, I have been saying repeatedly, and I'll say it again, every riot is an offense, but not every riot is an act of terrorism. And yet, this law is invoked when there is violence, when there is a riot. Yes, we know that the Indian Penal Code can be invoked. We know, for example, that charges of murder can be brought, but not charges of terrorism. And that is because I told you the only reason to do that is to keep these people behind bars, because bail cannot be granted, pre-trial bail. So our attack in India has been against this provision of law, which says that pre-trial bail cannot be granted unless an accused person shows that there is reason to believe that he or she is not guilty. Now, that's like asking me to prove that I'm not guilty, whereas we know that the burden of proof is on the prosecution and that we are entitled to the presumption of innocence. So this is, I would say, it goes to the heart of what we call the rule of law in this country. Now, let me illustrate this with these two cases I talked about. In the Delhi riots case, what were these young people protesting against? They were protesting against the Citizenship Amendment Act. The Citizenship Amendment Act is highly discriminatory. It offers a fast track to citizenship to those who were illegal migrants, but only if they belong to the Hindu community or are Buddhists, Jains, or Christians. It denies the same privilege to Muslims. And this is an act which created nationwide protests. And these young people that Sunita mentioned were arrested under anti-terror laws for protesting against this law where there was violence. Now, there was no link between them and the violence, except that it was alleged against them that they had organized protests. This is why the judgment of the Delhi High Court that Sunita talked about made international headlines, because the judgment said you cannot invoke an anti-terror law against those who are protesting, even if the protest leads to violence. Let's be very clear over here. Protest plus violence does not equal to terror. And therefore, the anti-terror laws cannot be invoked. Why is it? Because these protests were not targeted against the sovereignty of India. They were not targeted against the unity of India. They were not targeted against the security of India. They were protests against a law which these people considered unconstitutional. And if I may say so, I do consider these laws unconstitutional, and petitions are pending in court. But there's no law which says that you cannot protest against a law simply because a petition is pending in court. Let me take the second example, Bhima Korega. It's laughable that the objections against them in a solemn charge sheet filed in court is that they recited a poem by Bertolt Brecht at what has come to be known as the Elkar Parishad. They organized a parishad. A parishad is a congregation. It's a congress of people who get together for a discussion and for furthering their own political point of view. And at this meeting, which was, by the way, organized by a former judge of the Supreme Court of India and a former judge of the High Court, one of the participants recited a poem of Bertolt Brecht, in which he said that wherever there is oppression, there should be rebellion. Now, this, which was a poetic way of saying we must all protest oppression, was taken to be an act of terrorism. So there you go, two examples where there is no attack on the sovereignty of India, no attack on the security of the state, and yet this law has been invoked. Now, why does this happen? It happens because our government has collapsed the difference between a disagreement with the policy of the government of India and an attack on the Indian state. It is like saying the government for the time being is India, and India is the government, or even worse, a particular minister in the government of India is India, and India is a particular minister in the government of India. You simply cannot collapse these differences. There's an amazing confusion of thought over there, which is intended to keep these people behind bars. The other strategies that are used is invoking sedition. We still have a law of sedition in India, which has no business to be in a law in a democratic Republican form of government. Yet another strategy which is used is to invoke a law which says nothing should be done to create communal disharmony. I would like to say a few words about this. Here it is. If a minority community organizes itself and says, we are being targeted by the majority community, they will be held responsible for creating communal disharmony. Because this government doesn't recognize the difference between a minority and a majority. We are all one, regardless of our ethnicity, regardless of our religious beliefs. We are all supposed to be one Hindu nation. And that's really the root of the problem, the refusal to accept that we are a country with plural religions, all of which have a right to thrive in India. And therefore, these laws, which are intended to protect minorities, are being used against minorities. Yet, I was asked to say a few words about the modus operandi. I've explained to you how anti-terror laws are used, but here are a few more strategies that are used against minority communities and against dissenters. Multiple crimes.
Indira, you have about 1 minute left. Sorry.
Yes, I will finish by just mentioning another 3 or 4 modus operandi being used. One of them is when a person is about to be released on pre-trial bail, a new crime is registered against them. We call this evergreening of a crime. And therefore, there's no hope that you will ever be able to get out while trials are going on. Yet another strategy that is being used is you simply change the goalpost. And I'm going to end over here by giving you a couple of examples. While we were protesting the abrogation of Section 370 of the Constitution of India, which gave the state of Jammu and Kashmir a special status, they simply amended the law by saying that instead of consulting the state government, we need to consult the governor. And the government, it was president's rule at that time, so it was like the government of India taking permission from itself to alter the special status of the state of Jammu and Kashmir. And they just did it overnight by a simple notification, a presidential order. So there you are, changing the goalpost, changing the law through delegated legislation, through rules, through regulations, while the protest against these laws is still on. I'll stop here, because what I have tried to do is outline for you the various strategies that are used. The end game of all of this is to crush all forms of defense, all forms of protest. And as Sunita pointed out to you, I am also one of the victims of this end game, except that we refuse to keep quiet and go away. But I'd like to tell you that every law has been weaponized, whether it's the Foreign Contribution Act. We had contributions from Ford Foundation and from Open Society, and we've been told that we are corrupt. We've been told that we've laundered money. We've been told that we've violated the Foreign Contribution Act. Income Tax Act has been weaponized. The Money Laundering Act has been, you name it, and any law is used to crush dissent. Thank you for listening to me patiently.